Welcome back to the deep dive. Today, we're really opening up the playbook for commercial identity here in South Africa. We're taking a close look at the Trademarks Act 194 of 1993. It's basically the rule book for protecting, marketing, and, well, defending your brand.
Exactly. It's the foundation, really.
Yeah.
Assented to back in 93, started officially May 1st, 1995. But, just because it's got some age doesn't mean it's outdated. It's been updated, consolidated. Most recently, I think, May 2011. So it keeps up.
Right. Keeps pace with how business actually works now. And our goal today is pretty straightforward, is take this dense legal stuff and make it practical. The Act's main job, as I understand it, is registering trademarks the regular kind, but also these specialized ones, certification and collective marks.
That's right. Standard trademarks, certification marks, collective marks, and it covers all the related bits and pieces, too. So we'll start with the basics. What even is a mark? And crucially, what makes the registrar say no? Then we'll follow the application journey, look at that scary 5-year deadline for actually using the mark, and finally, dig into the real power registration gives you infringement, dealing with competitors, even globally.
Okay, sounds good. Let's start right there. Fundamentals. The Act defines mark very, very broadly. What kinds of things count?
Oh, it's incredibly inclusive.
Yeah.
A mark is, well, basically any sign you can represent graphically. So you've got the obvious stuff. Names, words, signatures, logos.
Yeah.
Devices, they call them, but also shapes, like the configuration of your product, patterns, ornamentation, even a specific color, or the container your goods come in, or, any mix of those.
That really does sound like they tried to cover almost anything visual. But wait, graphical representation? What about things you can't easily draw? Like if I have a signature sound for my app, or a unique smell for, say, a retail store, can those be trademarked under this Act?
That's a fantastic question, and it hits a key point. Because the Act specifies graphically represented things like smells or standalone sounds, they face a real challenge. Unless you can maybe represent a sound with musical notation or a very detailed visual description, it's tricky. The Act really leans towards things you can see or draw clearly.
Got it. So graphical is key, but just having a unique sign, like my special blue color, isn't automatically enough, is it? There's that crucial distinctiveness test.
Absolutely. That's the core requirement, Section 9. To get registered, a trademark has to be capable of distinguishing your goods or services from someone else's. And that capability can be, meaning it's just naturally unique from the start, or it can be something you build up through acquired distinctiveness.
Okay, and this is where it gets interesting for people trying to register. What doesn't pass that test? What are the big no-nos?
Right. Section 10 lays out the main hurdles. Think of 2 big categories. First, marks that are purely descriptive. You can't just grab a word everyone needs to use in that trade. So if your mark only describes the kind, quality, geographical origin, or purpose, like calling your apples crisp apples, that's usually out.
Because everyone needs to be able to say their apples are crisp, right?
Exactly. The second big one is about function. This is huge for product design. You can't register a mark that consists only of the shape, configuration, color, or pattern if those features are needed to get a specific technical result, or if the shape just comes from the nature of the goods themselves, like the basic shape of a brick.
Can you give an example of that technical result idea?
Sure. Think about something like Lego bricks. The specific shape with the studs and tubes, that's functional. Just what makes them connect. You couldn't trademark just that functional shape under trademark law because it gives a technical result locking together. That's more for patents, which have limited terms. Trademarks could last forever if used.
Right. Stops you getting an endless monopoly on a functional design through the back door of trademark law. Makes sense. And obviously anything dodgy is out too.
Precisely. The Act explicitly says no marks that are inherently deceptive or contrary to law or contra bonos mores, that's the legal term for against public morals or decency. Offensive stuff, misleading stuff, immediate rejection. And of course, if it's confusingly similar to a mark already on the register for similar goods or services, that's usually a refusal too.
But business isn't always neat. What if 2 companies honestly independently develop similar marks? Is there any wiggle room?
Yes, there is. Section 14 provides for honest concurrent use. It's a really important practical exception. Even if your mark looks confusingly similar to an existing one, the registrar or the court might still allow it if you can prove you've been using it honestly and concurrently, perhaps in a different area, or if there are other special circumstances. It acknowledges real-world business development.
Okay, so let's say I've navigated that. My mark is distinctive, it's not functional, it's not offensive. How do I actually get it registered? Talk us through the process.
Right. Part 4 covers the application. You apply to the registrar, who is the commissioner at the CIPC, the Companies and Intellectual Property Commission. The registrar looks at it and makes one of 4 calls, basically. Accept it as is, accept it with conditions or amendments. Provisionally refuse it, giving you a chance to respond, or refuse it outright. They have to tell you their decision in writing.
That sounds very internal between the applicant and the CIPC. But doesn't the public get a say?
Oh, absolutely. That's vital. Once the registrar accepts the application, maybe after some back and forth, it must be advertised. This kicks off a 3-month period where anyone who thinks they'd be harmed by the registration, maybe a competitor with a similar mark, can file an opposition under Section 21. It's a public scrutiny stage.
And this leads to the register itself. It's more than just a database, isn't it? It has legal weight.
Definitely.
Yeah.
The register is kept at the Trademarks Office, open for anyone to inspect, and its real power comes from Section 51. Getting your mark registered makes you the proprietor, and that registration is prima facie evidence of its validity. That means legally, it's presumed valid unless someone proves otherwise. It gives you a strong starting position.
Okay, acquisition covered. Now maintenance. What if I register a brilliant mark, but then, I don't know, my business plans change, and I just sit on it? Does the law care?
It cares a lot. Section 27 deals with removal for non-use, and it's got teeth. A mark can be removed if you never had a genuine bona fide intention to use it when you registered. But the more common issue is simple non-use over time. If 5 continuous years pass from the date the registration certificate was issued, and you haven't made any bona fide use of the mark for the goods or services it's registered for, it can be removed.
5 years, that seems like a fair deadline. You either use it or lose it, essentially. Stops people warehousing marks they never intend to commercialize.
Exactly. It clears out the dead wood from the register, making sure marks are actually active in commerce. And critically, the burden of proof is on the owner. You have to prove you used it if challenged, which can be harder than it sounds.
But lots of big brands don't use the mark directly everywhere. They license it franchisees, subsidiaries, partners. Does their use count for the owner?
Yes, it does if it's set up correctly as permitted use under Section 38. If a registered user, someone licensed by the proprietor, uses the mark according to the license agreement, that use is legally deemed to be used by the proprietor. It's essential for modern business models like franchising. It protects the main registration from cancellation just because the owner isn't the one directly applying the mark everywhere.
Right, that makes sense. So, assuming I've kept my registration alive and well, what are the actual powers it gives me if someone steps on my toes? Let's talk infringement.
This is where the registration really pays off. Section 33 says registration is basically your ticket to sue for statutory infringement, though, importantly, it doesn't kill off any common law rights you might have separately. Now, Section 34(1) outlines the main ways infringement happens. Think of 3 main scenarios.
Okay, break them down for us. What's the first, most obvious type?
The clearest case. Someone uses a mark that's identical to yours, or so similar it's deceptive, on the exact same goods or services you registered yours for. You register Zoom Cola, they start selling Zoom Cola or maybe Zuni Cola. Direct hit. Infringement.
Pretty straightforward. What's the next level?
This involves similarity, but maybe not identical. It's using an identical or similar mark on goods or services that are similar to yours if that use is likely to cause confusion or deception. So, maybe registered Galaxy shoes and someone launches Galaxy handbags. Shoes and handbags are similar enough in the fashion world that consumers might likely be confused about whether they come from the same company. That's likely infringement too.
Okay, makes sense. And the third type, that's the big one for famous brands, right? The dilution idea.
Exactly. Section 34(1)(c). This protects marks that are well known in South Africa. Here, infringement can happen even if someone uses your identical or similar mark on completely unrelated goods or services. The test is whether that use is likely to take unfair advantage of or be detrimental to the distinctive character or reputation of your well-known mark.
So if, say, a really famous luxury car brand finds its name being used on, I don't know, cheap cleaning products, nobody thinks the car company's making bleach, but the use might tarnish the luxury image or just piggyback unfairly on the fame.
Precisely. It's about protecting the brand's value and reputation, not just preventing source confusion. It stops tarnishment, blurring, or free riding on the goodwill the famous brand built up. It's a very powerful tool for established marks.
Are there ways someone could use a similar term legitimately without infringing? Any defenses?
Yes. Section 34(2) provides some important exceptions or defenses. A registered mark isn't infringed by someone making bona fide use of their own name or their business's place name. or, crucially, by someone making bona fide use of words to describe the kind, quality, quantity, purpose, value, geographical origin, or other characteristics of their goods or services. The key condition for all these is that the use must be consistent with fair practice. You can honestly describe your coffee as rich blend, even if someone registered rich blend coffee, as long as you're just describing it fairly and not trying to pass it off as their brand.
Okay. Fair use exceptions. Now, if infringement is proven, what can the brand owner actually get the court to order?
Several remedies. An interdict, it's a court order telling the infringer to stop immediately. They can also get an order for the removal of the infringing mark from goods or even delivery up of the infringing materials. And, of course, damages to compensate for the harm. But there's a neat alternative to damages in Section 34(3). The proprietor can choose instead to claim a reasonable royalty, what the infringer would have paid if they'd been a legitimate licensee. Sometimes that's easier to calculate and recover than proving actual lost profits.
That royalty option sounds very commercially savvy. And how does this system connect internationally? What about famous brands known worldwide but maybe not operating directly here?
That's covered by Section 35, reflecting commitments under the Paris Convention for protecting industrial property. It protects marks that are well known in the Republic, even if the owner doesn't actually do business here or have local goodwill in the traditional sense. The courts specifically have to consider how well known the mark is here because of its promotion internationally when deciding if it gets this protection.
Okay, that brings us nicely to those specialized marks you mentioned earlier, certification and collective marks. Can you just clarify the difference again?
Sure. A certification trademark, Section 42, isn't about indicating who made the product, but rather that the product meets certain standards, maybe relating to quality, materials, mode of manufacture, or origin. Think of things like the wool mark symbol, certifying pure new wool. The key rule is the owner of the certification mark cannot trade in the goods they're certifying. They have to be neutral. Then you have collective trademarks, Section 43. These do indicate a commercial source, but the source is membership in an association. The association owns the mark, and its members use it to show they belong to that group and distinguish their goods or services from non-members.
And collective marks are where geographical indicators often fit in, right? Protecting regional products.
Exactly. The Act specifically allows a geographical name to be registered as a collective mark. This is vital for, say, an association of rooibos tea farmers from a specific region. They can register the region's name as a collective mark, and only members meeting the association's standards can use it, protecting the product's regional identity and reputation.
Very useful. One last international point. Priority. If I file my trademark application in, say, the UK today, can I effectively backdate my South African application?
Yes, within limits. That's Section 63, dealing with convention applications. If you filed first in a convention country, one party, to the relevant international treaties, you can claim priority in South Africa. You have to file the South African application within 6 months of your first foreign filing date. If you do, your South African application is treated as if it were filed on the same date as the foreign one. It's crucial for managing international rollouts.
Okay, so wrapping this all up, what we see in the 1993 Act is a really comprehensive system. It starts with defining what can even be a mark graphically, goes through registration, deals with non-use, outlines infringement clearly, provides remedies like interdicts and royalties, and plugs into the global IP system.
It really is a complete framework. And don't forget it binds the state too, Section 4. Plus, there are actual criminal offenses in Part 16. Things like making fraudulent entries in the register, Section 60, or maybe commonly seen, falsely representing a mark as registered when it isn't, including improperly using that little R in a circle symbol, Section 62. That can lead to fines or even jail time. The system demands honesty.
It's detailed, structured, quite administrative in parts, but then you get to these core concepts like distinctiveness, likelihood of confusion, bona fide use, fair practice. These aren't always black and white.
That's the perfect point to end on. The Act sets up the rules, the registrar makes initial decisions, but ultimately the courts have the power to review those decisions, Section 57. They can even consider fresh evidence, Section 53. So, given how nuanced distinguishing marks can be, especially with modern branding, how much does the whole system's fairness really rely on judicial discretion, on the courts interpreting these complex rules in real-world disputes? That ability to review and adapt seems critical to making the whole thing work fairly.